May it please the Court, my name is Brownlow Spear, and I represent Mr. Ronald Milot. This is his appeal from the revocation of his probation by the Lowell District Court on the basis of a stabbing of which he was accused. At the end of the probation revocation proceeding, 3 continuances without a finding were revoked, and a sentence of 1 year in the House of Correction was imposed on him, and he noticed an appeal to the appeals court from the probation revocation. And while the appeal was pending, but before it was entered in the appeals court, he completed the House of Correction sentence and he was released, and shortly afterwards he pleaded guilty in the Middlesex Superior Court to the stabbing which had been the basis of the probation revocation. And he was sentenced to 3 to 5 years in the state prison, which he's currently serving. After the appeal from the probation revocation had been entered in the appeals court, and he had filed his brief in that court, the Commonwealth moved to dismiss the appeal as moot because of his plea of guilty to the charge which was the basis for the probation revocation. And several appeals court decisions hold that the appeal has indeed become moot by reason of the conviction of the charge which was the basis for the probation revocation. Our position is that those appeals court decisions are wrongly decided. And in order to get this court's decision of the issue of mootness, we applied for direct appellate review, and it was granted by this court. There are several reasons why we think that the appeal should not be held to be moot in these circumstances. Perhaps most important is that such a holding allows constitutional violations in probation revocation hearings to go unredressed.
Mr. Spear, is that actually true? I mean, isn't there another avenue to attack proceedings that are unconstitutional and which there's no right of appeal or there's no avenue of appeal? I mean, let me get to this. I mean, first of all, if you're right, so we send this back for what purpose? He's now pled guilty to the underlying offense. What is the purpose served here?
Well, I think the purpose served would be to cure a proceeding which we contend was unconstitutional.
And how is that cured? Now there, of course, will be no need for live witnesses, of course, just enter the convictions. And we're back to where we were.
For Mr. Milot, it would mean that he doesn't stand convicted of the 3 misdemeanors on which the continuances without finding were revoked.
So you're suggesting that there might be a different outcome?
Well, I don't know whether or not a further hearing would be warranted, or for that matter legal, Your Honor, in this unusual situation where he is in fact served all the time that was imposed by the court that revoked the probation. So it's an unusual case in that particular posture, and I think that would be a decision for the court if it agrees with our position that the probation revocation should be reversed.
Well, if there are unconstitutional practices going on in these proceedings, isn't there a 211(3) route to get to those?
Well, Your Honor, that is not a route as of right.
No.
It's not one which I think the court would say that it particularly encourages Well,
you're suggesting that if we let this go, then there might be unconstitutional practices festering out there in the district court, and surely there's a way to raise those.
Well, Your Honor, I think if one were to take a hypothetical 211(3) petition in this case, I think that the predictable response, whoever the single justice might be, would be that no, not a 211(3). You have a remedy by in the appellate process. So I mean that's I'd say entirely predictable to the point of being a virtual certainty.
Well, can you help me understand what should have happened here?
I think that the witness, the percipient, at least one of the percipient witnesses, should have been brought into the probation revocation proceeding and subjected to cross-examination and confrontation. The Gagnon versus Scarpelli due process rule is that the there has to be good cause found for not providing confrontation of such a witness, and there was absolutely none of that here, although it was pressed for by trial defense counsel at the probation revocation proceeding, Your Honor. That's why I think the underlying procedure was so defective.
Could we?
So to follow up on Judge Cordy's question, so let's say you prevail here. We send it back for that? He's already served the time, right?
Well, there's a second prong to the probation revocation proceeding, and that's whether his conduct would warrant an extension of the leaving the probation in force. And I've said in the brief that I think for that purpose, his conduct while in prison would be subject to being reviewed, and perhaps on that basis it could be found that he had conducted himself well and would be a fit candidate for continued probation. In this case, for the restoration of the continuances without a finding. As I say, Your Honor, I think the fact that he has served the time puts the case in a very unusual posture, and I don't really have a clear answer on that. I would leave open the possibility that no, they would be barred from a further probation revocation proceeding because he has served the time, which is an unusual feature.
Hypothetically, if let's say he had gotten into a lot of difficulty while he was serving that time, then he would be in the awkward position of perhaps having a new sentence imposed, right?
I don't believe, Your Honor, that the sentence could be increased beyond what it was.
Because then you'd be saying, well, he's already served the time.
Yes, you would be in that position. That's true. That's very true. You would be in the position of saying he's already served the time. In that hypothetical situation about a prisoner who's had been engaging in misconduct while in prison, obviously I don't want to stay within the record. That doesn't fit Mr. Milot's position. But yes, yeah, that would be a sort of a circular trap in which one might fall.
Is it important in this case that the defendant pleaded guilty to the subsequent charge as opposed to having been found guilty after a trial, and he could have even appealed it and then been acquitted?
I think under the appeals court jurisprudence, it's all the same. However he ended up being convicted, they say that it renders the appeal moot. So on the basis of the appeals court's jurisprudence in this area, it doesn't matter.
So even if he had been convicted, took an appeal on the subsequent conviction after a trial, and had his conviction reversed, and then was acquitted, it wouldn't make any difference.
Well, it would at that point. I think. Well, I'm sorry, I wasn't prepared for the hypothetical. I think that the standard is different. And that may, in fact, have been already, there may be a decision of this court on the point that the fact that the standard is different for probation revocation as opposed to a conviction of a crime, that the reversal of the conviction doesn't necessarily mean that the probation was wrongly revoked.
Yeah.
I'm confused by your claim that because probation may have been may be over, that he could not be, if you were to prevail, that he could not be retried for the probation violation. There are many times which a person is convicted, serves his time, and then after the time has been served, the conviction's vacated. Commonwealth can retry that person. Why is it different for probation?
Well, I didn't. I only was sort of keeping that open as a possibility, Your Honor. I didn't actually put that in the brief as a. It probably, if this court were to say that yes, there would be another proceeding, it's the second prong that would be open for decision, in which his conduct would come into play, and which I don't believe has been.
But you're not challenging that prong. You're challenging the evidentiary basis.
That's correct.
That's correct, Your Honor.
And on the prong question, wouldn't it be appropriate to be? I mean, don't you really have to go back in time? I mean, wouldn't the conduct be that since he's pled guilty, he committed those crimes?
Well, I have, you mean on the first prong, Your Honor?
No, I was thinking about the second. You say, well, you'd have the second prong about does it warrant imposition of the sentence or reprobating him, right?
I have addressed that in the brief, Your Honor. I've said, by analogy to the White case, I think if there were a reversal, that his entire conduct in the intervening period would become subject to review, and I would think it would apply in this situation. And
Thank you, sir.
thank the Court.
Good morning. May it please the Court, my name is Elizabeth Silverman. I'm an Assistant District Attorney for Middlesex for the Commonwealth. This Court should uphold Justice Armstrong's decision in Fallon and the appeals court cases that follow it and find that this case is moot because no actual controversy exists about whether the defendant has violated his probation now that he's pled guilty to the same facts. The protections at a probation revocation hearing are due process rights, and the touchstone of due process is an accurate and reliable determination. Once these same facts have already been established in a separate forum with higher protections at a higher standard of proof, we can be sure that due process has been met.
Well, but go ahead.
I was going to the question of the reliability of the hearsay, and let me just change the facts of this case a little bit. What if this were clearly a case of multiple hearsay in police reports that was not reliable? Would it still be moot?
If those facts had already been proven by a conviction, yes, then we know that those facts.
Okay, and if the conviction is appealed and reversed,
if once the conviction were be reversed, then we'd be in a different situation because there wouldn't be the assurance by the conviction that those facts had been established. At that point, it would not be moot.
So what renders this case moot is that the underlying conviction is final.
Yes.
Does the fact, this is an earlier question of Justice Spina's, but does the fact that it's a plea versus a conviction after a trial make a difference in your analysis?
The facts are established whether it's a plea or it's a conviction. I don't think it does for that respect, but I would add that in a case like this where it has been a plea, it makes a further judicial estoppel issue where the defendant has claimed to one court and to the superior court has asserted that he has committed these crimes and continues to assert that the finding of fact by a judge on the same set of facts was not sufficient.
But he's contesting the procedural aspect. He's just sitting silent at the violation of probation hearing and saying that the quality of the evidence that was presented against me there was not legitimate.
Which establishes the fact for the hearing. Anything, the procedures.
He's not taking inconsistent positions. He could have pleaded guilty in the trial on the crime and said absolutely nothing at the violation of probation hearing and saying that you proceeded against me in an illegal manner. You presented unreliable hearsay. And based on that alone, I was entitled not to have my probation violated.
And I would go back to the same argument that those facts have already been established. So let's.
Well, I guess if that were to happen, if in fact if it was unreliable hearsay, Justice Cordy's concerns would kick in and a 211-3 petition could be filed.
Exactly. And to touch back on another point that Justice Cordy had brought up earlier, that the effect of finding these cases not moot only at best for the defendant, it sends it back to the district court to have a hearing where at this point the probation officer would just summarily put in the certified copy of the conviction. There wouldn't be an issue about confrontation of a witness or whether they were.
Well, what if, let's say this case is not moot for this reason. We take a look at the quality of the evidence that was presented at the violation of probation hearing, and we say that it was wrong. It never should have happened. His probation should not have been violated. So now he's served a period of time for his violation of probation. He is now serving a sentence for the underlying crime. Does he get credit for time served on the new charge? I mean on the substantive crime?
If this court were to find that the defendant prevails, it would be sent back to the district court where there would be a new hearing. And presumptively, at that point, he would be found in violation again.
Anyway.
He would be fined, and there's no reason to suggest that there wouldn't be, the same sentence would be imposed.
What do you say, though, on that point to Mr. Spear's argument that, okay, yes, he would be found in violation, no question, because you've got this plea of guilty, but the disposition might change. You know, it might be, and it would matter in this case because it was a continuance without a finding, as he might be reprobated because of his conduct from then to now.
Your Honor, I would suggest that the disposition was based on the violation at that time, and there's no reason to believe that the same sentence wouldn't be, looking at the same factors, wouldn't be imposed again. The White case is a separate matter because that's a case of an illegal sentence where the defendant was entitled to resentencing and entitled to look back at the time period because there was an illegal sentence. Here, there was no illegal sentence imposed. This was in the discretion of the judge. And whether they would, again, look at whether his reasons for revoking probation would remain the same. They were based on the defendant's record of being on probation, how he was able to adhere or not to probation in the series of his new offense. I mean, what would only be clearer at the new hearing is that he had certainly violated.
I've never heard of mootness applied to a matter where there is consequence. Are you saying there's no consequence here to whether or not he's found to be in violation of probation?
There's no meaningful consequence because what would happen is that he would be sent back to the district court where we'd once again find that he was.
But you wouldn't say in a criminal case if a person has later confessed to a crime that his appeal of his underlying conviction is moot because if the conviction were to be reversed, you could simply go back and play his confession to the jury and he'd be found guilty again. I mean, I've never heard of a situation in which there's information developed after the trial that would make it easy to get a reconviction, and by that you say now that the appeal is moot. I've never heard of such a thing.
Your Honor, in the scenario that you're suggesting where it would go back to the criminal court, it would still be a matter of a judge or a jury finding that that confession constituted beyond a reasonable doubt of that crime. In the case of this, where the defendant's on limited liberty in a probation situation and we're sent back, this court has already said several times that the admission of the conviction, which constitutes the violation, will in itself constitute. So we are it is a certainty that there would be a violation.
But does that make it moot, or does that simply make it easy to undo the consequence of a reversal? Because the Commonwealth could, by the way, choose not to do that. The Commonwealth could say, I don't plan to. If it's not moot, and if there were a reversal, the Commonwealth could say, he's already served his time, we're not going to move again to violate his probation. And the consequence then would be he would have no convictions on these 3 charges, which may have substantial collateral consequence if he were to be convicted again, wouldn't it?
It could, and I would go back to the mootness lies in the fact that there isn't a controversy about whether the probation has been violated, and that's the reasoning on which the appeals court has developed this line of cases.
Based on events that occurred after the trial.
Yes, because if it had happened before the probation hearing, then the conviction would have satisfied it at that point.
But don't we lose something in this? Don't we lose something in because if something was wrong if something had gone wrong with the violation of probation, by saying it's moot, we're kind of winking. We're saying that, well, the integrity of the process is not that important, and in fact it is.
Of course it is, and of course probation surrender hearings are meant should always be conducted according to the rules and the protections. And I don't believe that in finding these cases moot means that we don't acknowledge the importance of those procedures. It's just that in the limited circumstances where the new offense is the exact, and only the new offense is what there's been a later conviction of, it's a matter of judicial economy.
But the imposition of the sentence might not, a judge might not impose a sentence on violation of probation, on remand.
But if the judge chose to impose that sentence at the first hearing, there's no reason to...
Well, shouldn't that judge decide?
But we count on the consistency of judges in the same circumstances.
Isn't the reason that somebody's been on probation and he commits another, he's alleged to have committed another offense, is there some gut reaction that, gee, this guy he wasn't deserving of probation and we got to get him off the streets right away?
I'm sorry, I'm not sure.
I mean, there are consequences that flow from the initial violation of probation that might not necessarily be identical on a remand.
You're suggesting the only issue is whether there was sufficient evidence of the violation. The fact that he has subsequently pled guilty to the underlying offense, really, there is no longer a controversy about whether, in fact, he violated his probation.
Exactly, Your Honor. That's the Commonwealth's position in this case. That's the circumstance of this case, that the defect that's alleged by the defendant goes to the sufficiency of the evidence, and for that reason it's moot. I see my time's up. Thank you, Your Honor.